salam always delivered to our Prophet Muhammadin Sallallahu Alaihi Wasallam. Ladies and gentlemen, in this special opportunity, as a moderator in this next section of our range of international short course, my name is Muhammadiyah Bangsawan as a moderator. In this special opportunity, to handle this discussion. And then before we are going to start our discussion today, let me say hello to our speaker. Welcome, Prof. Absori. I hope you very well in this special opportunity. Okay. Before we are going to start our discussion, we have to know about our speaker. So I will tell you the short bibliography of our speaker. Name is Professor Dr. Absori, birth in Brebes, 5 May 1963. Now, he is a head of Prodi, head of doctoral program in Faculty of Law, Universitas Muhammadiyah, Surakarta. He was already achieved the bachelor degree at Faculty of Law, Universitas Gadjah Mada on 1986, and then he was achieved the Master of Law in Universitas Diponegoro in 1991, and he was achieved the doctoral degree in Universitas Diponegoro in 2006. There's any several background based on the prediction or the lecture in Universitas Muhammadiyah Surakarta. There's any several publication who already published in international journal, Scopus indexing, or there's any several opinion who published in several media, national, regional, and international media. There's all about the short curriculum vitae for our beloved speaker. Without further ado, please welcome to our speaker, Professor Dr. Absori, to tell us about this topic, Indonesian legal policy framework for digital economy. Time is yours.
Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillah rabbil alamin wassalatu wassalamu ala asrofil anbiya'i wal mursalin wa ala alihi wa sahbihi ajmain. Amma ba'd. Thank you very much, audience, ladies and gentlemen. So, Mas Indra Bangsawan as moderator. In the opportunity, I will do presentation about the topic Indonesia legal policy framework for digital economy. My screen. Okay, I will start. Introduction. Legal politics are legal policy in creating and enforcing the law in state. It saw the pattern and the direction of legal development, as well how the law will be enforced, meaning reaching the legal goal and ideal with its justice in a legal state. What is the legal politics? legal politic stressing in enforcing, creating in state law. Indonesia state law called in Rechtsstaat, not Smakstat. So reaching the goal is justice in a legal state. Legal politics in developing countries such as Indonesia requires direction and input the profit, additional value in legal development, especially in the legal development framework in the economic sector. To reach this goal, the strategic step and required to encourage the acceleration of development in the economic legal sector, especially in framework of the digital economy. Legal development in developing countries. Legal development in developing countries such as Indonesia often adopt the law Western capitalist society. According Mark Weber, the Western legal system has crucial role in encouraging the rise of the capitalist economic and Western societies. The Western legal system is characterized by its higher rationality and logic compared to other legal system. The Western society is influenced by the spirit of capitalism that was inspired by protection religion, which perceived that hard work and success in life are deemed as the guarantee to enter heaven. Weber thought was inseparable from condition of the European capitalism society. Capitalist interest demanded the legal form to become more rational and profit more predictability for the accuracy of the capitalist economic process. Legal development, according to Mark Weber, there are 3 steps. Number 1 is departed from magically conditioned formalism and rationality conditioned revelation. And then number 2, it passed the state of theocratically or patrimonially conditioned certainty and informal expediency. And number 3, which then direct to the specialized juridical and logical rationality and systematization. Development of legal according to Friedman. According to Friedman, Loren Friedman, the legal development consists of the component. Legal substance, which is the correction of the law that contain institutionally used norm and regulation, as well as the behavior pattern of legal actor and legal system. And the second, legal structure, apparatus or institution that have the job to enforce the law, such as the police force, justice enforcers, judges, attorneys, and lawyers. And the 3, the third, the legal culture, namely culture, habit, perspectives, as well as in behaving and thinking in general societies that might influence social power towards certain better development. In Indonesia, the legal politic basis legal politik Indonesia is Constitution. Constitution 1955 special an Article 333. In Article 333, Clause 1 state the economic is arranged as a common for based on the principal concept. Article 33 clause. Yeah. Article 33 clause 2 state branches of production that are important for the state and to control the life interests of many people are under the power of the state. Article 3, the consistent the earth, water, and rights within them are used maximally for popular welfare. And Article 3T, Clause 4, Constitution state the national economic is established based on economic democracy under the principle of togetherness, efficiency, justice, sustainability, environmental awareness, and independence, as well as by maintaining the balances of the national development and unity. The next development of the digital economy in Indonesia. The development of science and technology in trading liberalization era has influenced various aspects of life, including the economic and trade sector throughout the Okay, I will continue to presentation. There's any trouble? The digital economic in used in economic activities and financial service and accommodation and transportation as so the economic activities and my efficiently run. The digital economy is media to carry out the marketing and the sales transaction of goods throughout the internet and social media such as Facebook and WhatsApp using mobile phones with, which are commonly used. pardon me, any trouble to internet. I will to continue the operation. The next, the digital economy is a media to carry out the marketing and the sales transaction of goods through the internet and social media such as Facebook and WhatsApp using mobile phone, which are accommodation used. The digital economic system rapidly developed through the visual business, such as virtual stores and virtual company. Business actors carry out their business using internet as the media. Benefit of the digital economic. Benefit of the digital economic. Therefore, the digital economic may be bring benefit to and encourage to economic growth and I see to online marketing of industrial product of micro, small, and medium enterprise and the large-scale business, as well as to profit online transportation service. From the legal aspect, effort to grow investment and the digital economic in Indonesia include the need to develop a legal framework that can guarantee and protect economic business according to the principle of healthy business competition. This legal framework must profit from for innovation as well as encourage Indonesia competitiveness as a target market state with large market transaction through the digital economy. In the end, the digital economy can profit more equality economic growth in society with low, middle, and high economic level, both in city and village. In the city, people have so far been used to using the internet and online media, such as online transaction and transportation, which will increase economic growth into a large scale. Issue on the digital economic. Number one, from the aspect of the digital economic infrastructure, the lack of internet network that can reach the wider society, including those in rural areas. Those economic actors experience difficulty access internet to market good the product more widely. And number two, the digital economic transactions are simpler without using conventional media such as paper. Involved party and business actor do not have to directly meet page to page. Thus, the digital economic may become a new economic driver that can reach a wider society without obstacles in the form of infrastructure or business location. Number three, the negative aspect that there may be proud. For instance, business owners might send items that are not identical with the photos of the item ordered. There may also be lateness in delivery because delivery might have visible flaw. In the aspect of payment, seller might feel that they have not obtained payment even though the buyer has paid. Number four, from the legal aspect, there are many economic actors that do not understand legal regulation, such as the law or agreement or contract transaction between parties and legal protection, including privacy, confidential personal data, such as data and intellectual property right of goods and product and financial transaction carried out by economic actor. Definition of the digital economic law. The economic law may be defined as the entirety of the legal principle, regulation, and decision that regulate digital economic activities. Economic activities may be carried out by society through individual, legal entities, or government through state-owned business enterprise. Another definition of the digital economic law is a series of economic activities conducted by economic actors using the internet and artificial intelligence. In this case, the digital economic may make change in society economics activities and business from manual model the automatic model. The legal framework of the digital economic. The digital economic requires legal framework, namely number one, legal principle on agreement in transaction. And number two, legal protection of related parties. Number three, dispute resolution in the case of issue. Number four, the use of computer in online transaction. Number five, infrastructure policy in the form of internet network availability that reach an urban and rural areas. Legal regulation of the digital economic. Legal regulation on the digital economic in Indonesia, there are many five legal. Number one, legal principle on the agreement between the concerned parties. Number two, law number 8, 1999 on consumer protection. Number three, law, and number 27 on to 22 and protection on personal data. Law number 19 of 2060 on electronic information and transaction. Law number 6, 2023 on the application of the regulation in law, the law on job creation. Legal principle of the agreement on the digital economic. The legal principle of the digital economic agreement are based on number one, the freedom to make contract carried out by related parties. Number two, consensus in the form of agreement in making contract. Number three, good faith as basis for agreement carried out. Number four, fakta serpanda, meaning that agreement are complete with as a law that been concerned parties. Apart from other principle must be observed, namely number one, the principle carefulness, meaning that the party must pay attention with all aspects may potentially cause harm. Number two, the principal benefit, electronic technology are aimed to support the information process and to increase the efficiency of the digital economy. Number three, the principle of healthy business competition, party that carry out business activities through the digital economic must truly, fairly, and honestly by prioritizing the quality of the product to increase the competitiveness. Number four, the the principle of the legal certain activities carried out by party obtain a guarantee of the legal certainty. Law, business, competition, digital economic. The law of the digital economic need the support with extent of the legal instrument on business competition carried out by business actor and the local, regional, national, and global level. Additionally, the dispute resolution or enforcement of the law on business competition may be carried out by the Supervision Commission on Business Competition called Komisi Pengawas Persaingan Usaha, and the party that conduct the business activities. In undergoing business transaction and activities, business actor need to have list of the other business actor with good track record. Apart from that, there need to healthy business competition guidelines to AC transaction and guarantee AC in undergoing business. This is so that it might be conducted safely, efficiently, and profitably. Law number 8, 99 on consumer protection. The law consumer protection regulation, consumer right and the responsibility of related principle, related parties. Number 1, consumer right to include the rights for comfort and safety, the right to correct, clear, and honest information, the right to have their opinion and complain on product heard, the right to obtain correct, honesty, and non-discrimination treatment, the right to obtain consumer development and education, the right to obtain compensation if the obtained items are unsustainable, the right to obtain adequate advocacy for consumer protection. Consumer responsibility. Consumer responsibility are in the form, number 1, informative responsibility. Business actor must provide adequate and clear information for consumer in closing good so that they do not choose wrongly. Responsibility toward good product. In the case where there are no agreement, the responsibility of product in case and damage, pollution, and harm experienced by consumer due to consuming to produce good. Responsibility and security. This aim to prevent to unwanted event. Therefore, there needs to be a guarantee of computer system security, communication security, and physical security of code. The next law number 27 to 2022 on the protection of the personal data. In the principle in law number 27 to 2022 is that protection of personal data in a form of human right to provide security and personal data. Thus, there need to be legal protection for personal data, including in economic or commercial activities. Law on the protection of personal data regulates the forms of personal data, subject right to personal data, obligation to control personal data, transfer of personal data, legal sanction, international cooperation, societal participation, dispute resolution, or prohibition against the use of the personal data and protection personal data. Law 90 2096 on electronic information and transaction. The law on electronic information and transaction regulates this various information on transaction via electronic media. Electronic information are a set of the electronic data in the form of the process writing, images, sound, photos, letters, and so on that contain certain meaning of or understanding. Electronic transactions are legal action carried out using computer network, and other electronic media. This law also states that anyone who purposefully and without right on legally access to computer and electronic system or other people through any method be imposed with sanction. Such action are categorized as the law violating action that might be imposed with punishment under criminal law, such as imprison or other sanction according to legal regulation. Thus, there needs to be legal socialization through the various media to grow society understanding of the electronic transaction and the benefit of that law existence. Benefit of law on electronic information and transaction are: number one, to guarantee legal certainty in conducting electronic transaction. To prevent crime through electronic media such as the internet, to protect society, internet user from online criminal action. Number four, encourage the extensive climate of the investment and economic growth in Indonesia. Law number 6, 2023 on the application of regulation in law of the law on job creation. Law on job creation is a legal policy in encouraging the development of investment and economic business, including the digital economic business. It is hoped that law and job creation will encourage the recovery of the national and global economic to achieve social welfare. Apart from that, the law on job creation is also legal policy that regulates various interests in facing global challenges. It is simultaneously a strategy to speed the economic recovery after the COVID-19 pandemic. In the economic sector, it is to encourage digital transformation. The job creation law regulation in law number 6, 2023 on the application of the governmental regulation number 2, 2022 on job creation, also regulation economic development, including national digital economy. Content law job creation. Simplification of business licensing, investment requirement, employment, component and protection. easy of doing business, research and innovation support, government administration, land recruitment, government investment and project, economic area, and then the telecommunication and broadcasting sector as a spot for the digital economic. In this case, there is regulation on extension of infrastructure development, the protection and AC of investment, healthy business competition, the use of new technology, and access to electronic information and transaction. The job creation law also regulated the obligation of the central and the regional government to facilitate various IC to investment and economic as well as digital technology, so that a very person can access information and communication technologies in the form of digital facilities. The policy of the procurement of the infrastructure network in the form of the internet in various urban and rural areas may easy society in honor of small, medium, and large business to conduct digital economic business activities. This policy will be the end encourage the growth, investment, and economic. It will bring prosperity to society. To grow investment to the digital economic, there need to be policy on the awarding of business incentive, tax holiday policy, and import duty reduction and exemption policy. The issue in obtaining business permit and the simplification of permit institution through a single door system, such as the investment cooperation agency called the Badan Kerjasama Penanaman Modal (BKPM). If dispute solution will discuss about the resolution dispute in digital economic. Dispute resolution digital economic by alternative dispute resolution is digital economic dispute settlement model carried out cooperatively outside the court, outside the court, which the directed at agreement or solution that is win-win solution. This win-win solution is agreement that is able to reflect interest of the party involved in digital economic dispute. According Karl Renner said that the development of the law work out what is socially reasonable. A dispute can only be understood if it is based on the view of legal complexity, namely that the formal and non-formal sector which arise in society are always compatible with each other. When the law or formal process break down, then the power autonomy will take over to find way out on its own. Emergency of alternative dispute resolution in the web business dispute resolution cycle that occurred in the United States of America. The settlement business economic dispute in era globalization has characteristics of the moving quickly according to way that are informal procedure and the pure motion quickly. Negotiation of the parties. Negotiation is a negotiation process carried out to initiative of the parties themselves. Negotiation process that is carried out by way of deliberation. Bargaining is made to reach an mutual agreement between the dispute parties. The success of negotiation is largely determined by the good intention of the parties themselves to carry out content of the agreement. At the end of the mediation, mediation is way of the resolving dispute facilities by a mediator. The parties to the dispute may consist of two or more persons. In this case, the party whose role and mediator is one unit with the party to dispute and is partial in nature. Mediator only facilitate the parties and the party to dispute themselves propose the way of resolution. According to COPAC, mediation is a process by which neutral third party, the mediator, assess dispute party and reaching the mutual satisfactory resolution. Mediator duty to access the dispute party to find solution. The mediator does not have the authority to make decision during the negotiation process. The purpose of the mediation is to reach agreement acceptable to parties to end the dispute. Settlement dispute through the arbitration. Arbitration regulated in the law Treaty 1999 concerning arbitration alternative dispute resolution. Regulated the choice to the party to solving dispute through the deliberation between party carried out by establishing a court institution outside the general court. What is arbitration? Arbitration body is made of the setting dispute carried out by a specially appointed third party. Arbitration is civil court system that is those who oversee the authority and obligation are party themselves. Decision used by body that are final. The arbitration decision is binding the parties. Arbitration decisions are independent and free from state interferences. The party may choose on the arbitration who, according to their belief, has adequate knowledge, experience, background, and issue in dispute is honest and fair. The party can determine the choice of law to resolve the problem as well as the process and the venue for arbitration. Arbitration or in decision that is binding on the party through a simple procedure or directly enforceable. Okay, I think it is my presentation. The next, please, moderator, to continue discuss. Thank you very much.
Okay, thank you so much for Professor Absori for the great presenting, and we hope you enjoy our discussion in this special opportunity. Okay, as we near the end of our sessions, we'd like to open up floor if there's any questions you may have to our expert speakers. You can click the raise hand feature or type on the room chat Zoom if there's any questions. As we know, the topic that we have discussed today, we'll talk about how the economy both in after the pandemic era, and then how the portrait in Indonesia. As we know, the many policies and regulating is already taken by the governments. The final goals of all the regulations to achieve and reach the economic goals after the pandemic. So to make a deep discussions in this special opportunity, I invite for all the participants in every the country, because there's any participants from in Asia, and then in Europe, or in Middle East, and then for all the participants from Indonesia too, for students. If there's any questions, please you can ask the speakers with raise your hands, or you can type in on the room chat Zoom. As we know, the speakers already present to give the portrait of our economic development in Indonesia. So I hope the participant maybe can give the several opinions how the treat of government to encourage their economic growth during the after the pandemic era. And then maybe there's some comparisons. If there's any participants want to send to us in this special or in this section, don't be hesitate, because this is the forum that we can put together, we discuss, and I hope all the participants can give their effort to make these sections a success as well. Okay, I will invite for all the participants, if there's any questions, you can click the feature raise hand or the room chat Zoom, and I will deciding, and our expected speaker will give the answers, as many as possible.
By subject question. Sudah?
Okay, thank you. There's any question from Selina Albert. I will deciding for the speaker. First, what regulation does Indonesia present to protect cybersecurity? And secondly, what institutions are used to protect data in Indonesia? There's any two questions from Selina Albert to our speaker. I will invite you to answer this question.
Only one question. To protect cybersecurity in Indonesia.
Yeah.
Okay, thank you very much for your question. To protect cybersecurity in Indonesia, this body have authority to protection. In Indonesia, only the police cut and the party themselves. So it is the problem very crowded, because some cash in Indonesia there isn't to protect. For example, kasus name Borji, yeah, in can the Borji in Indonesia, government of Indonesia not ability to protect the cybersecurity, and this problem global, and maybe in the next time need to the thinking again to make the body has responsibility to protect cyber security. I think it is maybe Mas Indra can question again.
Okay, thank you so much for the answer from Prof. Absori about how the regulations about cybersecurity and the institutions with look if you look the portrait of today. Okay, thank you so much for the questions. Now we are going to the next questions from Ani Farida. Yeah, this is the first question is how governments with OJK handle online loans post many fake attempts. Kemudian, and then the second is nothing virtual transaction without trust. How build trust in virtual transactions? There's any two questions. First, how OJK handle the loans causes, and the second is how to build trust in virtual transaction. There's a question from Annie Farida, Prof. We invite you to answer this question.
Yes, maybe OJK there is to take over the problem economic digital in order consumer of Indonesian society can feel safe, will adapt to transaction by banking or electronic transaction. OJK, of course, there are connection with some institution in finance, so in bank institution, and OJK have authority to handle some problem. And the authority again, OJK, in the next time take over to some problem in digital economic, especially in transaction online, and so media, internet. I think it is Indra.
Okay, that's the answer for the question from our participant, Miss Ani Farida. We're talking about the OJK and then how to build a trust in virtual transaction. I hope the answer will make sure the not as a final, but I think you can give the answer or several information. Okay, I will invite again once more, yeah, because we still have time until 40 minutes again, yeah, or 30 minutes again. And I hope the participant can still to build and then give the information, if there's any some information in several countries, how to describe the policies about the economic regulating. Okay, as we know, the big theme of our theme in this section talking about the economic regulation, but in the practice we can give many cause and then we can discuss it if there's any other cause. And for the information, today the government of Indonesia still give what is it? We can say it about the attention how to build a good protection in economy digital with the several approach. Start from the administration approach, how to make the regulation give a guarantee for all the consumer, for all the society in Indonesia, and then for the another sector from the private sector, how their roles to make sure all the content or all the transactions will be protected. There's several informations about the Indonesian's economy digital portrait. Okay, before we are going to close our discussion in these sections, as a moderator, I will tell you to fulfill the presence or for attendance in this special opportunity. I will share it in the room chat Zoom. Please, for all the participants, can fill in the participant attendance. Yeah, I already sent the participants' attendance in this room chat Zoom. We still waiting for your participant to joining the next section, because this is the days for our international short course. Still have for 2 days more to finish our short course. Okay, ladies and gentlemen, for all participants, before we are going to say goodbye, I'd like to say thank you so much for all the participants, and I'd like to say thank you so much for our expected speaker, Professor Dr. Absori M.Hum, who already come and joining with us to discuss about the economy digital framework in Indonesia. I hope this information will give you a good knowledge how to build and then how to produce the opinion about the economy. So, as a moderator, I have sorry if I really apologize if there's some trouble during these sections. I hope we can meet again in the next section. Thank you so much for joining us today. Billahi sabil haq, fastabiqul khairat. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.